Okay, perfect. So it's 1 p.m. and Paula will be starting.
Okay. Good afternoon, everybody. Thank you so much for joining us for Navigating IEPs. My name is Paula West Hernandez, and I'm a project manager here at TASC. Before we get started, I want to go over a few webinar details with you and to introduce you to Luisa Castillo, who will be our host and also helping out with chat. As she put in the chat, she's going to be sharing the webinar handouts with you, and they'll include a list of resources as well as the PowerPoint handout. If you have questions, please put them in chat. Everybody is muted, and so if you do want to ask questions, please be sure to put them in chat, and we will be answering those questions in the middle of the webinar and also at the end. So Luisa will be reading those questions out to our presenter, Angie Escobar, who will be speaking with you in just a minute for the presentation. At the close of our webinar, we are funded by federal and state grants. So our grant providers want us to ask some questions to make sure that we're doing the job that they're funding us to do. But we also want to know the answers to the survey questions so that we can improve our services in any way or continue doing what you guys like. So if you can please make sure to complete that survey, and it also helps us to continue to provide free services. And I don't know about you all, but I love that free price tag on. So if you can fill out the survey webinar at the close of the webinar, that would be wonderful. So we'd like to welcome you all, and I'm going to turn it over now to Angie Escobar, who is our presenter. She's a bilingual Spanish-speaking family support specialist from our San Diego office. Angie?
Thank you so much. Good afternoon, everybody. Again, my name is Angie Escobar. I am a bilingual family support specialist, and I have been with TASC for about 4 years. I do have 4 children, and 3 of them with disabilities, and that's just something that I wanted to share. So let me tell you a little bit about our services for those of you who do not know who TASC is. TASC is a nonprofit, and we serve 6 counties, Orange, LA and Ventura, Riverside, San Diego, and the Imperial Valley area. We are a family empowerment center. Our main office, our main corporate office, Rea. Some of the services that we provide here at TASC are individualized assistance. Right now, because of the situation with COVID-19, we are doing more of telephone assistance. Usually in our office, we also we're doing a one-on-one in-person consultations. We review a child's IEP documents. We also provide educational workshops such as this one. I do like to invite all of you to visit our website at www.tascca.org, where you can view workshops. So again, we also provide educational workshops, and we do community outreach. In our area office, we do have our tech center. This is just a TASC disclaimer. TASC staff does not advise parents as to the nature of a child's disability or needs, nor do we recommend placements or therapies. We educate and empower people with disabilities and their families. That's our mission statement. So this workshop is called Navigating IEPs. And this is our workshop agenda. We're going to go over eligibility under IDEA, the assessment timelines, provisions under IDEA, developments of the IEP, alternative dispute resolution, due process, and records request. The following slide contains special education acronyms. First, let me explain to you the meaning of IDEA. It is an acronym for the Individuals with Disabilities Educational Act. This is our nation's special education law. It was first passed in 1975, where it was called the Education for All Children's Act. Every few years, the law has been revised, which is a process called reauthorization. The most current version of IDEA is public law passed in 2004 and called the Individuals with Disabilities Education Improvement Act of 2004. The main purpose of IDEA is to provide FAPE. FAPE means a free and appropriate public education. Free and appropriate public education. Under IDEA, public schools are required to provide each child with a disability with a free and appropriate public education in their least restrictive environment, under public supervision and at no cost to the child's parents. FAPE refers to special education and related services designed to meet the unique needs of the child and prepare the child for further education, employment, and independent living. FAPE requires that school districts provide special education to meet the unique needs of your child. This means specially designed instruction. For example, a child with reading issues might be taught with multisensory reading program. It also creates an individualized education program for your child. This is a written plan for your child's special education experience at school. By law, an IEP must include things like services, progress monitoring, annual goals, and much more. And in the upcoming slides, I'm gonna go more in detail about what that is. It also needs to teach your child in their least restrictive environment, or LRE. As much as possible, your child should be learning alongside students who receive special education. Placements in a separate class is only allowed if it's necessary to meet your child's needs. Okay, the least restrictive environment isn't a place, it's a principle that guides your child's educational program. Special education law says that your child should be learning with their peers. In our previous slide, we learned that LRE is part of the Individuals with Disabilities Education Act, or IDEA. IDEA says that children who receive special education services should learn in their least restrictive environment. Again, this means that they should be spending as much time as possible with peers who do not receive special education. Special education, special classes, separate schools, or removals from the general education class should only happen when your child's learning or thinking difference, a quote disability under IDEA, is so severe that supplementary aids and services cannot be provided, cannot provide your child with an appropriate education. Least restrictive environment placement decisions. Placement decisions are made by the IEP team members. So who are the team members? You, because you're the parent, at least one of your child's special education teacher or provider, one regular education teacher, a representative of a school district that can make decisions, and an expert can interpret evaluation results. So usually there's a school psychologist, and may include professionals as well. It will be discussed during IEP annual meetings. So there will be situations where an emergency IEP meetings must take place to discuss a change of placement. So it doesn't necessarily have to happen at the annual IEP meetings. You know, situations can arise where an emergency IEP meeting has to be called in to discuss a possible change of placement. It is determined, at least, you know, annually. There are specific situations, again, where a change of placement takes place. So before this happens, a meeting has to take place, and again, this is a team decision. Our next slide talks about related services. So related services means transportation and such developmental, corrective, and other supportive services that are required to assist a child with a disability to benefit from special education, and includes speech and language pathologists. So the list here, the slide contains, a list of other related services providers as well as speech and language pathologists, audiology, physical therapists, occupational therapy. Transportation is also part of related services, counseling, mobility, school nursing services, parent counseling and training. So related services includes, all these professionals and other, services. Our next slide talks about fair assessment evaluation procedures. So the law states that the public agency must provide notice to the parents that describe any evaluation procedures the agency proposes to conduct. This is usually done with something called a prior written notice, which I will explain in detail in the upcoming slides. You can also refer to a handout that Luisa will share on chat box. And this is just a blank prior written notice template, so that you have an idea what it's supposed to include and how it looks like. In conducting the evaluation, the public agency must do the following, as stated in the slide. Determine whether the child is a child with a disability. Assess the child in all areas of suspected disability. Use a variety of assessment tools and strategies to gather relevant functional, developmental, and academic information. Use more than a single measure or assessment to determine the appropriate education program for a child. In addition, each public agency must ensure that assessments and other evaluation materials used to assess the child under this part are selected and administered so as not to be discriminatory on any racial or cultural basis, that it is provided and administered in the child's native language or other mode of communication, and in the form most likely to yield accurate information on what the child knows and what they can do academically, developmentally, functionally, unless it's clearly not feasible to so provide or administered. So, and the assessments also have to be administered by trained and knowledgeable personnel. Special education eligibility begins with a referral. So if you suspect that your child may have a disability or could benefit from special education services, your first step is to contact your school district and request an evaluation. So the IEP referral should be done in writing, and it should be dated, signed. You can make a copy and submit it directly to your child's school principal, the school psychologist, or your child's teacher. When you request that your child be evaluated for special education, this is called a referral. Referrals can be initiated by the SST or the student study team, or sometimes it is directly requested by the parents. So you put in your request in writing and you submit it directly. You don't have to go through the SST personnel. You can just submit it directly. The Individuals with Disabilities Education Act, or IDEA, mandates that school districts have the responsibility to identify, find, and evaluate the students who live within their boundaries who are suspected of having a disability, and this is called child find. During the IEP meeting, the school psychologist and other professionals may go over their assessment results, and if your child qualifies for special education services, then the IEP will be developed. So remember, you are a part of the IEP team members. So once the IEP is created and developed, then you are a part of that as well. Related services and placement will be determined by the team at the IEP meeting. Our next slide provides it's a task sample assessment letter. So, it says your special education director, and then you want to put your child's name, date of birth, request for assessment evaluation. You're requesting a special education assessment for your son or daughter. You're requesting an assessment in all areas of suspected disability, and specifically in the area of, and then you want to put down what is it that, you want your child to be assessed on. You want to include some of your concerns, what they are based on, anything that you see, any struggles that you see, at home, or, any struggles that your child has, you want to include in the letter. It's also important that, if you're going to be requesting a psychoeducational assessment, but you also want your child to be assessed in other areas that, you can, mention those in your letter. Mental health assessments, functional behavior assessments, those are separate assessments, so may not necessarily be a part of psychoeducational, but those are separate assessments that are done separately. You can always include them in your letter. And I just want to that we have sample letters that we can share with you. They are not included in this presentation here, but if you would like those sample letters, please feel free to drop your email address so that we can email them to you. Okay, and make sure to tailor these letters to your child's needs and any information that you may want to share, with your school. Okay, and the other slides, it says that you understand that you will be presented with a written assessment plan within 15 days, and that the plan will inform you of the test to be given, dates for the test, and the names of the persons who will administer the test, as well as explanations of the test and their purpose, and then you sign it. So again, it's recommended that you make a copy for yourself. We want to keep record, of any request that we make to our school districts. We want to keep record of that and put it in our child's home file. This slide shows the assessment timeline for California. Timelines vary by state. So the timelines vary around the country from 45 days to 60 days. You must learn your state special education regulation requirements. So we invite you to visit your State Department's education website. Okay, so this explains that it's 15 calendar days for the district to respond to the parent's request, 15 calendar days for parents to sign the assessment plan. So after your request, you will receive an assessment plan, which will include all the assessments that your school will do. Again, this will include, psychoeducational assessments and other assessments, depending on what you request, functional behavior assessment, or, mental health assessments, or, any other ones. And then the school has 60 calendar days. The district has to complete the assessments and schedule the IEP meeting. Again, this assessment timeline is for California, so we do invite you to visit your State Department's education website for more information on assessment timelines. Our next slide talks about re-evaluation triennials. So they must occur at least every 3 years unless the parent and the public agency agree otherwise, and re-evaluation is unnecessary. So note, a re-evaluation may occur no more than once a year unless the parent and the public agencies agree otherwise. Re-evaluations are done to determine the child's continued eligibility under IDEA, to determine determine the need for continued related services and special education, and to determine new present levels of performance for goals. So earlier we talked about, IEP team members. Who are they? So the parent of the child. So you are a part of the IEP team members. Other individuals can include professionals providing related services to students, such as speech language pathologies, occupational therapies, any ABA therapy support agencies. It can also include other agencies such as DOR or Department of Rehab, regional center, any disability rights agencies, social workers can also be involved. As previously stated, IEP team members also include a regular education teacher, special ed teacher, representative of the school district again, an assessor who can interpret evaluation results, and other individuals who have knowledge or expertise regarding your child, and when appropriate, the child with a disability. In developing each child's IEP, the IEP team must consider these points here on the slide: the strengths of the child, the concerns of the parents, the results of the assessments, the present levels of performance, positive behavior interventions. If your child has a behavior intervention plan, this will be included in the child's IEP, okay? Now, this is not automatic. Behavior intervention plans are not automatic. They don't go on the IEP unless, your child has perhaps had a functional behavior assessment and a behavior intervention plan has been incorporated into your child's IEP. The communication needs of the child, and the assistive technology needs of the child. Okay, in considering the communication needs of the child, and in the case of a child who is deaf or hard of hearing, consider the child's language and communication needs, including opportunities for direct instruction in the child's language and communication mode, and consider whether this child needs assistive technology devices and services. The Individualized Education Program, or IEP document, contains the following: statement of the child's present levels of academic achievement and functional performance. When members of the when the members of a child's IEP team sit down and together and consider how the child will be involved and participate in school life, they must be sure that the resulting IEP contains the specific information required by IDEA, our nation's special education law. So again, this list here tells you what IDEA, a brief list of what IDEA requires. So the present levels of performance, the statements of measurable annual goals, including academic and functional goals, description of how progress towards meeting annual goals will be measured, a description of how periodic progress reports to parents will be provided, a statement of special education and related services to be provided. Okay, and explanation of when the child will not participate with non-disabled children in the general education class, projected dates for the beginning of services, as well as frequency, location, and duration of services, a statement of the individual transition plan, or ITP, including post-secondary goals to be effected at age 16 or perhaps a little earlier as determined by the IEP team. Other extra IEP contents for students with disabilities. So for students approaching the end of the secondary school education, the IEP must also include statements about what is called transition services, which are designed to help youth with disabilities prepare for life after high school. IDEA requires that beginning no later than the first IEP to be in effect when the child turns 16 or younger if determined appropriate by the IEP team. The IEP must include measurable post-secondary goals based upon age-appropriate transition assessments that are related to training, education, employment, and where appropriate, independent living skills and transition services, including course of study needed to assist the child in reaching those goals. Also, I like to add that beginning no later than 1 year before the child reaches the age of majority under state law, the IEP must include a statement that the child has been informed of his rights under Part B of IDEA, if any, that will transfer to the child once the child reaches the age of majority. The ITP, it's the individual transition plan. So transition planning begins no later than when the student turns age 16. So parents or students can ask the school to start transition planning before the age of 16 if deemed appropriate. It is a good start early, for students with significant disabilities or students who are at risk for dropping out of school should also start early. Transition planning begins with a transition assessment. The transition assessment includes information about the students' interests, their skills, any challenges that they are might be facing. It also includes assessments of independent living skills and the students' readiness to transition into adult life. This assessment includes the student plans after high school. This can be done during an interview. Some students need to present the information using alternate forms of communication, such as pictures, videos, and or assistive technology if an interview is not possible. ITP meetings and IEP meetings, the public agency must invite the child with a disability to attend the IEP team meetings. If a purpose of the meeting will be consideration of the post-secondary goals for the child and the transition services needed to assist the child in reaching those goals, then if possible, they should be invited. And if the student is not able to attend, then the public agency must take other steps to ensure that the child's preference and interest are considered and discussed. Okay, so again, ITP require when children reach age 16. It can be written at the yearly IEP meeting or through a special individual ITP meeting. Includes a course of studies needed to assist the child in reaching the goals, and it is reviewed at the yearly IEP meeting. Okay. Our next slide, now we're gonna go into the diploma and certificate slide. So this is something that may be discussed when your child enters middle school during an IEP meeting. So you may wish to review child's IEP to make sure that this information is included, whether he or she will be diploma or certificate bound. So as the slide states, for students who are on diploma track, students must meet district graduation requirements. The district must provide a free and appropriate public education to students with an IEP until the age of 22 who have not completed graduation requirements by the end of 12th grade. Students can participate in all graduation activities and ceremonies, even if they have not met all graduation requirements by the end of their senior year. If a student has not met graduation requirements by the end of the senior year, then the IEP team will determine goals, services, and placements to help student graduate by age 22. Okay, so the other part is a certificate track. So students have, in a certificate track, students have satisfactorily completed the prescribed alternative course of study approved by the school board, or students have satisfactorily meet their IEP goals and objectives during high school as determined by the IEP team, or students have satisfactorily attended high school, participated in the instruction as prescribed in the IEP, and have met the objectives of transition plan. Students who meet the criteria for certificates are eligible to participate in any graduation ceremony and any school activity related to graduation. Okay, and I'm going to just ask, if you guys have any questions, please feel free to write your questions on chat box so that Luisa can read them out loud or respond to you.
And then Angie, can you hear me as my,
Yes.
am I unmuted? Okay, I just want to mention too that we are offering services right now through Zoom in terms of IEP consultations. So we're doing everything remotely. And so all services are free, and families and professionals can call us by phone, or they can, and then when speaking with a family support specialist, if that family support specialist and the parent or professional feel that they'd like to have documents reviewed, or it's necessary to review documents in order to move forward with providing options to the parent or the professional, then an IEP consultation can be scheduled, and the parent will sign a release form giving task permission to review their documents. And once that is done, then the documents can be emailed to us, and we can set up a face-to-face Zoom meeting and go over that with you. So we're still offering free IEP consultations. We're just doing it remotely right now.
Thank you so much for that. Yes. If anybody has any questions, again, please feel free to write them down on chat box so that Luisa can read them out loud. And then we're still gonna ask, I'm still gonna ask, if you guys have further questions towards the end of this webinar.
We do have some questions. Angie, would you like me to read them out loud now, or we can end till the end of the session?
You can read them out loud now.
Okay. So if we don't, if we're not able to address them all at this moment, we will ask again at the end of the session. But so far, Lupe asked, with COVID-19, how will we test students?
Do you want to answer that, Angie, or do you want to co-present on this one?
Co-present on this one.
Okay, all right. So right now they're doing things remotely. In most instances, it's still okay to do things face-to-face as long as social distancing, mask wearing, and all of the precautions for protecting students and the assessors are put into place. And that's determined, with the parent and the student and the professional. So they're doing some of those things. However, there's some instances where it isn't feasible to do testing. So in the cases where we can do testing, then we move forward with that, and we can determine services that need to be provided. If there's areas that can't be tested for some reason, then we may have to wait until we can meet and do more face-to-face kinds of testing, and then determine the need for service in those particular areas. So it's kind of a hybrid, and we're, right now, most of our counties, of course, we're on the watch list. So we're all doing things remotely at this point. And we're going to be talking, I know Angie's going to be presenting a slide on how assessment timelines have been impacted by a Senate bill that has been passed as a result of school closures. So she'll be talking about that in a little bit.
Great. Another question that we have is from Joe. Before the virus, I had put in a referral for my child who was in the 5th grade and was waiting for a meeting. Now with the new school year starting soon, will I need to put in a new referral because he will be starting 6th grade at a different school?
Okay, can you read that one again, Louisa?
Sure. Sure. Before the virus, I had put in a referral for my child who was in the 5th grade and was waiting for a meeting. Now with the new school year starting soon, will I need to put in a new referral because he will be starting 6th grade at a different school?
Angie, do you want to take that one, or would you like to co-present?
So the child is going to another school, right?
Yes.
Yeah, but I'd like to know, I have a question, I'm sorry.
Sure.
Go ahead.
I'd like to know, so was this a referral for an assessment? So you started a referral for an assessment at one school and nothing happened while he was in the 5th grade as a result of your request for an assessment. And now your son's moving to a different school in the 6th grade. Are we understanding the question correctly?
It seems so. If Joe wants to clarify, she can write it down on the chat box. But I'm taking a guess that's what it is. I'm not sure if the letter was submitted to the district or to the school.
Yeah, and that's what I wanted. That's what I'd like to know. So if that's the scenario, so if you presented the case to the, if you asked for an assessment from the school district, and when your child was in 5th grade, now you've moved to a new district, but the first school district hasn't responded to you, right? And I'm sorry, Luisa, is it within the district or a school within the same district or a different district?
I don't have any additional information. So if Joe Derabny would like to add additional details, or if you would like this to be answered through, private message, let me know.
Okay, so so let me answer the question as I'm understanding it. And if I'm incorrect, if you want to unmute her or him, then we can answer more directly maybe. But so, right, if you had a referral and your child was not assessed, you're at the very beginning stages of the assessment process. What happened on March 17th of 2020, a Senate bill was passed called Senate Bill 117. And that bill changed the assessment timeline. And it states that districts don't have to comply with providing an assessment plan or responding to the parent within the 15 calendar day timeline. And if that because schools are closed. And so this time is being considered, even those kids were receiving instruction for implementation purposes, it was considered to be outside of the normal school year. And so because of that, districts do not have to provide assessment plans to parents. And unless the parent can review the assessment plan and sign the assessment plan to consent to the proposed assessments that the district wants to provide, then the assessments can't move forward. So Senate Bill 117 kind of changed that whole assessment process. And so if that happened, that could be the reason why the district did not respond to you. However, they should have provided you with prior written notice, letting you know why they didn't respond, letting you know what the alternatives are, letting you know the steps that they took to reach their decision, which would have been SB 117. And letting you know what the alternatives are to you and where you can get more information about how you can appeal the decision. So that should have happened. Now that your child's going into a new school year, if it's within the same district, then the same, that same assessment plan should follow. But we still have Senate Bill 117 in place. So until schools reopen to brick and mortar schools, they don't have to provide an assessment timeline or an assessment plan, within the 15 calendar days. So that's still going to hold true. If your child's going to a new district that isn't on the watch list and the kids are in school, then the timeline should start. You'll need to start all over again and apply to the new district. If you're in a new district, then you'll need to start the assessment timeline over again or write to that new district, make a new referral. And if they're not on the watch list and kids are going to school, then the timeline should move forward. Mm-hmm. Okay, I'm not sure if that, yeah.
We have a few more questions. I'm not sure if you would like me to ask them now or move forward.
Go ahead.
And
so we have Maggie. The school will begin via a full distance learning. Can we ask an in-person IEP meeting?
Not at this point. You may want to check with your school district. I believe they are doing all IEP meetings right now via Zoom. So that's the latest information I have.
Okay, and then from Michelle Wang, we have our child is currently sighted. However, her condition, which is also medically documented by multiple doctors, she will be blind, most likely in elementary age. How can we navigate the IEP so she can get the services now before she goes blind? We were rejected on basis that she is not blind yet.
Paula, can you help me answer?
Sure, absolutely. Well, I just want you all to know I am blind. So, but that doesn't help with this particular question. But let me see. So, if your child has medical diagnosis that she is losing vision, now just because you have a medical diagnosis, the district doesn't have to qualify the child under that category. However, if her visual impairment or her vision loss is keeping her from being educated or receiving benefit from her special education services, or preventing her from making progress in general education toward meeting standard Common Core state standards, now they need to look at that under child find. Does she require special ed services? So we don't need to just look at her academics. We need to look at her overall functioning. Can she navigate around her home, in her neighborhood, and when she's on the school campus, can she navigate on the school campus safely? Can she access the playground? Is her vision changing to the point where she's not able to read the board? She can't read the paperwork that the teacher is handing out. She can't complete assignments. She needs things to be read to her. So those are the kinds of things that if those things are happening, then you can ask for an assessment to determine eligibility under visual impairment, to include an assessment by an orientation and mobility instructor, by a visual impairment teacher or teacher of the visually impaired. If she has residual vision now, which it sounds like she does, you want to get maybe a low vision specialist to come in and determine if lighting makes a difference. Does she need large print, and does she need to use a video magnifier? So we should also have an assistive technology assessment conducted as part of the overall package, because with visual impairment, children have differing degrees of visual impairment that they can use, and there's all kinds of assistive technology, both verbal and magnified, that can help the child. So the first place to start would be to determine, to start documenting how her visual impairment keeps her from being educated, and then go from there and put those things in an assessment request. A lot of the things that can be, some of the assessments can be conducted virtually. Some of them, like a low vision screening to determine lighting and what assistive technology might be necessary, those might be more in person. But again, if they're done safely, we can't, I know that districts are doing some in-person trainings if we're following social protocol. So that would get you started. And then if you have any more questions, you can always email TASK and ask to speak with a family support specialist. The email address is task@taskca.org. Your case will be signed to a family support specialist, and then that person will get back to you, and you can discuss this more in length.
Okay, and then our next question is from Georgina. My son has speech and OT services on his IEP, but with schools being closed, he hasn't received these services. Do you know what I can request? Do you know if I can request these services be provided by an outside provider? And will the district pay for that?
Do you want to answer that, Angie, or do you want?
Can you repeat the question, Luisa, again?
Yes, definitely. So it's, my son has speech and OT services on his IEP, but with the schools being closed, he hasn't received these services. Do you know if I can request these services be provided by an outside provider? And will the district pay for these?
That's like compensatory, Paula.
Yes. So at this time, so if you want the district to fund any services, the IEP team, individual education program team, has to meet. And then that has to be written into the IEP that the district is going to fund services with an outside agency. Otherwise, if it's not in the IEP, they don't have to provide that service. So what you can do at this time, if they have not provided any services, you can write to the school district, to both the occupational therapy and physical therapist. If those are the people who have not provided services, write to them, let them know that your child has not received any services, and copy the director of special education on your letter. Explain to them that your child hasn't received any services from the date that you notice that services stopped being provided until the end date. So include the duration of that, a non-service. And then also too, if you have noticed that your child is losing functional capability, then it's really important for you to start collecting data, start documenting, what was your child's capability when services first stopped happening, and what are the capabilities now. Start collecting data. You can do that by taking video. If you have video demonstrating the capability when this all first started, services stopped, and now what is it, the video showing now, so the video can tell the story of what your child's functioning capability is today versus when this all started. It's going to be important to collect data, because unless you can demonstrate the level of regression, and if it's significant, the level of compensatory services that may be required to help your child to make up for that lost time. So I think that, to get those services paid for by an outside agency, you're going to have to meet as an IEP team and get the district members of the team to agree with you on providing those services.
Great, thank you. And then we have another parent, Rosa Isela. How does getting a certificate impact them when they are trying to obtain employment?
It doesn't impact them. They can still, apply for employment. If it's up to them, if the student, if they want to, disclose that they have a disability, but having unless it's like a job which has specific requirements, it shouldn't really, impact if they have a certificate. There are a lot of agencies who place, to match them with employers. So, and also just because they have a certificate doesn't mean, for some students are able to go back and work towards earning a high school diploma. We understand that it doesn't, it applies, situation may be different. So, but just know that there is that option. They can go back and apply, and to get a high school diploma.
Okay. And then the last question for now, we have, hello, what is the best next step if I did not sign the IEP due to errors and misrepresentations in the psychoeducational portion of an IEP multidisciplinary report?
Okay, so actually that's coming up in our upcoming slides. So you do have options if you disagree with the school district's assessment results. So I'll go, I'll talk more in detail in a bit here, but you just know that you do have the option. If you disagree with the assessment results, you have the option to request a private assessment at school district's expense. And also if there were errors, you also have the option to have those errors revised or corrected.
Okay, we can go on.
Okay. Thank you so much for your questions. Again, we'll have another session for, a Q&A session towards the end of the webinar. So our next slide talks about parents' requests for IEP meetings. So you don't have to wait until your annual IEP meeting to address any questions or any concerns that you may have. You are welcome to put in a request in writing if there's something that you need to discuss. It's important that if you do need to make a request for an IEP meeting, again, that you submit the request in writing. So make a copy and add it to your home file. So it's very important that anytime you're going to make a request, and especially for an IEP meeting, to address a concern or talk about any issue, that you put this in writing. So a reminder, if you were to request an emergency IEP meeting to address a question, a concern, an issue, make sure that you state that it's urgent, and the school will schedule within a reasonable amount of time. So for general IEP meetings requests, the district will hold an IEP meeting within 30 calendar days upon receipt of your written request. Okay, our next slide gives you your signature options. So this is usually found at the last page of the IEP. So if you agree to all parts of the IEP, then you can sign and return. If you are checking the second box, which says I agree with the IEP with the exception of, then you may wish, to include a separate sheet of paper and write down what is it that you disagree with. Again, this is an option that you have to let the school district know, that you still have some questions or concerns, or that you don't fully agree with all of the IEP. I mean, you may not agree with the placement, you may not agree with the goals, you may not agree with the related services. So you want to let the IEP team know what is it that you disagree with. Also, remember that you don't have to sign the IEP document that same moment, once your meeting ends. You have the option to take that IEP home for your review, and then once you have reviewed, and if you're okay with it, you can sign it and return it back within a reasonable amount of time, of course. If you feel like you need to have another IEP meeting because you still have questions and concerns that were not addressed in your IEP meeting, then please make sure to notify the IEP team members so that a continuation meeting can be scheduled for you. You don't need to sign anything else other than the attendance sheet that in an IEP meeting will be scheduled, and you should receive an IEP meeting notice for that continuation meeting. Okay. And this is a slide which talks about your right to make a request for a private assessment at public expense should you disagree with your school district's assessment results. So parents have the right to obtain an independent educational evaluation, or IEE, at public expense. If you as a parent disagree with an evaluation, the school district without delay has to do these two things: either file a due process complaint to request a hearing to show that their evaluation is appropriate, or ensure that an IEE is provided at public expense. If your school district grants you your request, then they can offer a list of district-approved providers. Parents may consider, but you also have the option to select an assessor who, from the non-public agency list, which meets the criteria of the qualifications of the examiner. So you are not required to provide an explanation. We will also upload, we'll share with you a sample letter on how to request an IEE at a public expense via chat box. So please drop your email if you would like to obtain this to be emailed to you. If you are denied an IEE, the school district will provide you with a prior written notice, which we provided a sample earlier on what that looks like, explaining why it was denied. So we'll talk about this on the next slide. Okay. Okay, Luisa, if you can please upload the sample prior written notice on chat box. So prior written notice, the district proposes to initiate or change the identification, evaluation, or educational placement of the child, or the provisions of FAPE to a child. Or if the district refuses to initiate or change the identification, evaluation, or educational placement of the child, or the provision of FAPE to the child. Prior written notice includes a description of the action proposed or refused by the agency. So, the prior written notice will be provided whenever, an assessment is denied, a service is denied. Whenever you put a request in writing, and if it gets denied, you have to make sure to obtain a prior written notice. Okay. With the prior written notice, you as a parent have, you have options. So you can, appeal a prior written notice. So just know that you have those options. It's important to also look into your procedural safeguards, which is provided during your IEP meeting. I know that most of the time, when it's provided to us, we don't look at them. And, I did that in the past, I wasn't really reading it, but, I urge you that, if you are in an IEP meeting and you get the procedural safeguards, go over it, again, don't sign the IEP, take it home, and also take the time to go over those procedural safeguards, because it will give you your rights and your options. Okay, so this slide talks about due process. So due process is a formal legal method of resolution of a disagreement or issue related to special education IEP process. The district or the parents may request a due process hearing. So this is one of your options, one of your rights, that you have under the law of IDEA. Once the parent or district files a request for a due process hearing, the student remains in the last agreed upon educational placement and continues to receive the last agreed upon service until the matter is resolved through resolution, mediation, or by a hearing officer. This is referred to as stay put. In addition, all timelines and legal requirements continue to apply. So 2 ways to resolve. The first one is through ADR. Okay, so ADR is an informal method of settling disagreements that may arise during an IEP meeting. So ADR uses specific options of this process to open communication, promote understanding, and reach agreements that promote or strengthen relationships. ADR is designed to meet the interests of the parties involved that result in a mutually agreed outcome, rather than a decision made by a third party, such as a hearing officer or, or a judge. So ADR is, considered to be less adversarial than a due process hearing. The other way is through impartial hearing. So whenever a due process complaint is received, the parent or the local education agency involved in the dispute must have an opportunity for an impartial due process hearing. So you have the right to request an impartial due process hearing regarding the identification, the assessment, and educational placement of your child, or the provisions of FAPE. A trained hearing officer will hear the evidence and issue a hearing decision. Okay, so just want to, also offer the option, to all parents that before initiating a due process procedure, before exercising that right that you have, that you try to resolve all your concerns at a school district level, of course, first, and, and try to address all your concerns, request meetings, again, put in your, request. If you need to meet, to put it in writing. So try to address everything at a school district level first. And then, if you wish to consider due process, then, that is your right. That is the option that you have. Okay. So alternative dispute resolution, or ADR. Again, ADR provides an informal process for disputes and is also less adversarial than a due process hearing. So ADR, it provides an informal process for dispute resolution. It can be provided by the Director of Special Education from your local special education local plan area, from the Office of Administrative Hearings, or OAH. The Office of Administrative Hearings provides a neutral facilitators as well. And you can read more about these options. Again, these options would be on your procedural safeguards. You can also visit California Department of Education to read more information about it. Okay, dispute examples. Disagreements may include the need to complete assessments to provide eligibility, determination, to change or increase services, or to change placement. Denial to complete assessments to provide eligibility, determination, to change or increase services, or to change placement. Those are examples. Okay. Steps into process. We have resolution meetings. So a resolution meeting is a dispute resolution process that takes place after a parent files for a due process complaint. Resolution meetings offer parents and school district the opportunity to resolve issues before a due process hearing happens. So participants include the parent, somebody from the school district who can make decisions on behalf of the school district, and individualized education program IEP team members who have knowledge about the facts listed on your due process complaint. A parent may also choose to bring an advocate, an attorney, or other support person. The parent and school district decide together which members of the IEP team should attend the resolution meeting. Some states may provide facilitators for resolution meetings when requested by the parent and the school district. So there is no requirement in the idea that facilitators be made available for resolution meetings. A parent or district may request a mediation-only conference. So this is another option. Requests for mediations only are filed with the Office of Administrative Hearings, and a copy of the request must be provided by the district at the same time that the request is filed with the Office of Administrative Hearings. So both the parents and the district must voluntarily agree to participate. Attendees at a mediation-only session should include the parent, a representative of the school district who has the authority to make decisions, and a mediator. An interpreter may be required if the parent requests one. A parent or the district may be accompanied and advised by non-attorney representatives. Attorneys or other independent contractors used to provide legal advocacy services may not participate in the mediation-only conference. Okay, I also talked about impartial hearings on the previous slide, where an impartial trained officer hears the evidence, and usually they will issue a hearing decision. Okay, I briefly mentioned about the stay put option as well. So the stay put provision is one of the most important legal rights in special education law. The stay put rights apply when you dispute a change of placement, a change the school wants to make to your child's IEP. So when you invoke this right, your child's current placement can remain the same until your school resolves the dispute. When you invoke this right, your child's current placement can remain the same until you and the school resolve the dispute. Keep in mind, some states have more protective stay put laws. So in these states, the stay put may go into effect automatically without any action on your part. In other states, you can invoke the stay put rights without filing a formal complaint. So you need to check, I invite you to check with your parent training and information center for your state's specific rules. Okay, I also want to let you guys know that there is an exception as well. So the school can move your child up to 45 days, even if you disagree with the move, if the current placement is likely to cause, to result in an injury to your child, or, put the safety of others at risk, then the school can move your child, also, for example, if your child was dealing with, just an example, drugs or carrying a weapon, the school can make the change temporarily. So during those 45 school days, the school is required to provide services to address the child's behavioral problems. So if your child has not, if you have behavior concerns, and if your child has never, been assessed, you also have the option to request a functional behavior assessment. If your child already has an IEP, but they've never had a behavior assessment done. So you have the option to make a request for that. Okay. Requesting school records. So parents can review all school records until their child graduates high school. Parents should receive records within 5 business days. Districts should not charge more than the actual cost of reproduction records.
Angie?
Yes.
And so this timeline has also been changed because of Senate Bill 117.
Yes, that's coming up on my next.
Perfect.
On my upcoming slides. It's okay.
All right.
Yes, but I'm glad you brought it up though, because it's important to know. Remember this. Yes. Yeah. So, okay. So we have a sample letter requesting school records. Okay. So this is a letter that we put up here for you. Again, if you need more sample letters, please email us. We have several, so feel free to send us an email, and we'll be happy to email you those sample letters. Recording the IEP meeting. Federal law does not prohibit a parent or school official from recording IEP meetings. State Department of Education's or school district can require, prohibit, limit, or regulate the use of recording devices at IEP meetings. Okay, many states have languages in their special ed regulations about their policy on audio and video taping. So I invite you to check your state's regulation about recording. Schools cannot record meetings while prohibited parents from recording. Okay, and the slide, in California, parents, you need to provide the school district with a 24-hour written notice of your intent to record the meeting. Our next slide talks about the consent to use medical or private insurance. So parents' consent is voluntarily and it can be revoked at any time. So if you're going to revoke, make sure that, again, you put in that request in writing. School districts are responsible to provide IEP services if the parent does not consent to medical or private insurance billing. So remember, the school also needs to provide FAPE, a free and an appropriate public education. So your consent for medical or private insurance billing is voluntarily and can be revoked at any time. Okay, so our next slide is SB 117, impacting the rights of students during COVID-19. So as you know, we are going through many changes. Although federal laws do remain the same in idea, every state has imposed their new laws. So again, if you are, here and you're from another state, we invite you to check with your state on what those, new laws could be for your state. So on Tuesday, March 17 of this year, Governor Newsom signed SB 117, an education finance bill that addresses school closures due to coronavirus or COVID-19 crisis. The new law took effect immediately. SB 117 impacts California students with disabilities, special education rights. It waives many education timelines while public schools are closed due to COVID-19. The bullet points on this slide state the special education timelines that SB 117 waives. The right to receive an assessment plan within 15 days. After your child is referred for special education assessment, the right to receive copies of your child's school records within 5 business days after a request before an IEP meeting or before any due process hearing or resolution session. When your child enrolls in a new school district, the right to have your former school district send your child's records to the new one within 5 business days. SB 117 also extends timelines under the Uniform Complaint Procedure or UCP by the length of time a school is closed due to COVID-19. So those timelines will start again once the schools reopen and the regular school sessions starts again. So SB 117 considers your school closed even if it offers independent studies or online distance learning or both. The special education timelines that SB 117 waives are state law requirements. SB 117 does not waive any federal requirements imposed under the Federal Individuals with Disabilities Education Act or IDEA. So for more information on this specific related bill, you can visit disabilityrightsca.org. Again, disabilityrightsca.org. So Luisa will include this website on chat box. And to know more about how the schools will look like during this, pandemic, please stay tuned because we will be having a series of 3 workshops in the month of August. Okay, so our next slide talks about the importance of maintaining a home file. Please document if you feel like your child is experiencing any regression, as Paula mentioned earlier, you want to document, gather data so that you're able to share it with the IEP team and let them know how your child was impacted. So it is important to maintain an organized home file of the child's records. Their educational records should include their educational history, any private evaluations, any special education evaluations, copies of the IEP, contact list, work samples, medical history, medical records, diagnosis, family history. So, you want to keep all those, you want to keep all the data. You know, as I mentioned earlier in the webinar, I have 4 kids, 3 with disabilities, 1 currently in the process, you know, of getting an assessment. But gosh, my files are just, you know, too much. I keep everything. I document everything, and I literally have binders of information, important information, you know, which it will be helpful, not just because, you know, because you know, will be because your child has an IEP, but perhaps you are applying for other services as well, you know, where you will need to go back to your records and retrieve information to be able to share it with other agencies. Okay, and we're gonna have a question and answer session. Again, we're gonna answer some questions. If you can please write them down on chat box. Luisa will read them. And if you can please take, you know, 2 minutes of your time to please fill out our survey, please click on the following link. Okay, but right now, if you wanna write down any questions that you may have on chat box. Thank you so much for attending this webinar. Thank you so much for your time. And again, we invite you to visit our website, www.taskca.org, for upcoming online webinars. And we're having our 3 series workshops in August. And this is something that, you know, it's going to be very good, and you know, you may want to sign up and register because it's a lot of good information. Thank you.
Hello. So we do have a few questions. So I just wanted to mention that if you guys, many of you are asking me if you guys can get notified via email of our future webinars. Yes, you can definitely call our office or email us to be added to the email list, and that way you can receive these notifications. Okay. So the first question we have is
something went wrong. Try again in a few seconds.
I apologize. That's my Google Doc. I don't know why she said that.
Oh, no worries. Okay, so
Sorry.
the first question is, when we request school records, will it include any assessments as well as results that were done?
Okay, if you're gonna make the request, you want to be specific, okay? Because sometimes, and this happened to me personally, it did not include it. It did not include any, you know, assessments. I did get copies of the IEPs. I did get copies of meeting notices, amendments, okay? But I did not receive copies of assessment requests. So I did have to make sure to put that, you know, specifically in my request, you know, make sure that you put it, that you want to request also copies of assessment results.
And then can I just make a comment about the survey, the link?
Yes.
Okay. So if you're a professional participating in this webinar, some of the questions may not pertain to you, because so if they don't pertain to you, please just put NA rather than a low mark, because, you know, so we want to know if it pertains to you, then we definitely want to know how you would respond to it. But if it doesn't pertain to you, please put NA. Thank you.
Thank you.
Okay, good. Now, the next question we have, give me 1 second. At what point do you suggest that family and caregivers utilize an educational attorney?
At what point? I mean, it is an option that you have. We understand that, you know, sometimes parents are just unable to work with their school districts. Maybe they have already attempted that. Maybe they have already tried to resolve situations at a school district level and that didn't work out. So it would be, you know, your option, and whenever you feel like you can no longer, you know, resolve anything at the school district level. So it would be up to you based on whatever experience you have already had. And if you feel like you have already attempted everything and you're just not able to get to an agreement. And
if I could add to that too, so it's really important, as Angie has been stressing throughout the webinar, to try to come to a collaboration between the members of the IEP team, the parent and district members. You guys are the ones who have been working with the child, and you know the child, especially the parent knows the child the best, but the teachers and the other people who have been working with the child also know what is going on. And if the team can come to a resolution without involving attorneys, then the child is going to be served faster. So it's really important to collaborate with schools, as Angie has been saying. We promote collaboration between districts and parents because children get better services and faster services that way. Once you get attorneys involved, many times the decision-making powers are taken out of the hands of parents and they're put in the hands of somebody who doesn't really know the child that well. And while they're, you know, they're professionals and they know how to handle subpoenas and all of that, they might not know your child and what you hoped to gain for your child. So like Angie said, it's really a personal choice, but an attorney should be retained after, like Angie said, after all other avenues have been pursued with the district, write to them, try to get written responses from the district so that you have, if you do need to appeal, because communication has broken down to the point that it cannot be restored, you have something in writing that your attorney can work with.
Yes.
Thank you. We have another question from Norma. I'm not understanding very much, so I invite you, if you can please ask your question again. I'm so sorry about this. Also, we have another one from Diana. If I disagree with the goals, but school insists, what can I do to solve this?
If you disagree with the goals, well, you are an equal IEP team member. So if you disagree with something on the IEP, you have, you know, the option to let them know. Again, on that last page of the IEP, you have the option to say that you disagree with, that you agree, you know, with some, but not all. And then you may want to elaborate more about what is it that you disagree with. So you are always, you know, welcome to ask for another IEP meeting to discuss, you know, any further questions, any concerns, any disagreements, really, you know. So just know that you have those options. So you are also welcome to if you have, you know, specific goals that you would like them to consider, please put them in writing and present it, you know, before an IEP meeting, you know, so that it can be discussed.
Thank you. Then another one, as a resource teacher, I was told that I will have to test 3-year-olds. I know that you have to have a credential to test. Is there an ED code to use when teachers without the credential are told to test 3-year-olds?
Can we research that? Unless, Angie, do you have an answer to that one?
No, not on that one, actually. No.
Okay, we'd like to. That's a great question.
Yeah.
And I'm not aware of an actual ED code. I do know that it says that assessors have to be qualified, and so here's a consideration. If you're a resource specialist teacher, does your credential and your licensure, does that provide grade levels or age levels that you can work with? So if it does, and it states that, for instance, that you can work with kids that are 1st grade through 6th grade, then that would prohibit you from assessing a 3-year-old. If you, however, have an early intervention credential, and then that probably would qualify you to assess that child. That's the only thing I can think of right now. I know I hold a single subject teaching credential, so I can work with students from 1st grade through, well, community college, but I can only deal with them for social science purposes. I can only teach social science purposes if I use my credential. So I wouldn't be eligible to do that kind of an assessment, but I'm not a resource specialist teacher either. It's a general ed credential. So I think you'd look at the ages that you're allowed to work with, first of all, through your credential. But if you'll leave your email, either in chat or email us at the email address is task@taskca.org. We will look up the ED code to see if we can find anything and then get back to you.
Okay, thank you. And then the other question we have from Norma, I have a youth who tested at a kindergarten level, but she is getting instruction out of that educational level. It was brought up to the attention of the IEP team at school, but nothing was done. All they said was the curriculum is adapted to student. What can you do to advocate for youth? She is getting instruction out of her understanding level. You want me to ask it again? To say it again?
Yes, please. Can you read it again?
It says, I have a youth who tested at a kindergarten level, but she is getting instruction out of that educational level. It was brought up to the attention of the IEP team at school, but nothing was done. All they said was that curriculum is adapted to student. What can you do to advocate for youth? She is getting instruction out of her understanding level. So meaning, I believe they're teaching her at that level. So if she's in kindergarten level, they're teaching her at kindergarten level. So is that appropriate?
I think she said out of educational level.
Yeah, I think she's she's getting instruction at a higher level. She's
Out of,
functioning
no,
at
it says
kindergarten.
she is getting instruction out of that educational level.
Okay.
Meaning, once again, I'll read it. Out of the educational level, sorry, she just cleared it up on the chat. So yeah, she is getting instruction out of the educational level.
So she's getting education above kindergarten level, right? It's above
Yes.
it.
Yes.
Yeah. Okay. Okay. So in other words, her instruction level is higher than her testing level, where she tested at. Okay. So
Yes.
Angie, do you want to go ahead?
Okay. What kind of placement does this does a student have? If you can respond to a chat box, what is the
She
placement?
tested at kindergarten level.
No, but the placement. What
The
kind of
placement.
classroom is she in? Is she in a special day class, an SAI class? Specialized academic instruction?
Special day class.
A special day. Is it moderate? Is it mild to moderate or moderate
Moderate.
to severe?
Mild to moderate or moderate to severe? Not sure.
Okay, is it in a class that teaches academic content, or is it more for functional, functional skills?
Not sure.
Okay.
I want to give you the option of, emailing us so that we can further look into it. I will be happy to review your students' IEP documents so that we can look more further into it and then provide you with options. Because
Okay.
we have to look at, find out what kind of placement the student has, what kind of placement and what that setting looks like.
She said that was fine. Thank you, Norma. So it seems that's it for now. Those are the questions that we have for now.
Thank you so much for those questions. And if you guys have further questions, if you guys need to talk to us again, we are assisting families over the phone. We can do a Zoom meeting. We can do a phone consultation. If you need us to review your documents, please feel free to send us an email so that we can get in contact with you and arrange for that. And if there are no further questions, if you can please take again a couple minutes of your time to please fill out our survey. Just click on the link below, the SurveyMonkey survey.
Some of you are saying, I'm so sorry that the survey link is not well, you cannot click on it and take you directly. So if that's the issue, you can also write it down on your browser and it'll take you, or if not, if you are having a problem with it, I can make sure to include the link on the email that I'll be sending to all of you that provided an email.